Hey, Kevin.
Hello, Rebecca.
Guess what we're doing?
It's the Readathon.
Construction edition.
Why do you call it that?
Well, we have a little construction happening in a room adjacent to this one, but we didn't want to make you wait for this readathon, so you might hear a little sawing, a little hammering, and that's just going to have to be okay.
Those busy Keebler elves are back there.
Exactly. So, Kevin.
Yeah.
Today was the final motions hearing before Tuesday's opening arguments.
Okay. Yeah, we're still we thought that this jury selection thing was wrapped up and that we would have opening arguments this week. We don't.
We don't. We actually have jurors as of yesterday. We've got 18 jurors.
Okay.
9 men, 9 women is the breakdown. All right. So that's all we know. So I was incorrect before when I said we had a jury. I thought we had. That was some of the
Well,
reporting.
you have a jury, but we
didn't have enough alternates.
Okay.
And interestingly enough, I did watch some of the the Twitter going along with the jury selection. The camera was not obviously on for that, but apparently a couple of jurors, one or more jurors, were booted because of stuff they had posted on social media. So jurors that had already been selected lied to get onto the jury.
Why do people...
They want to be on the jury.
They want to be on the jury.
They're lying to get on the jury.
Was there any... I guess the indication would be which
they must have
party
been anti-Karen
objected?
Read because it was the defense.
The defense brought it up and... Okay.
Yeah.
All right.
So somebody, likely an anti-Karen Read person, at least one, lied to get on the jury.
All right. Yeah, and not uncommon.
Also,
not uncommon. I mean, the people that... Yeah, it tracks. It does track.
Okay, so one thing I wanted to mention is, do you know who Lindsay Higgins is?
No.
Our audience may or may not know who this is. This is John O'Keefe's ex-girlfriend, not the one you've seen speaking on his behalf on his TV specials, the woman who dated him 10 million years ago, who calls him Johnny and wears the little necklace.
Yeah, right.
This is a woman who dated him in 2018. She's pro-Karen Read. I watched an interview with her earlier today, and there's a bunch of interviews with her. She talks about why she became pro-Karen Read. She heard that Johnny died. She was really upset. She was following the story. The news reports didn't add up to her, so she asked for the court stuff, like she called and did a records request, read everything, and came to the conclusion that Karen did not kill John O'Keefe.
Right.
She's been in the courtrum a lot, and she was in the courtroom today supporting Karen. I just wanted to mention that.
Interesting.
That's part of the visual. She was right there on the camera. All right, so...
Was the juror from her first trial also there? Could you tell? Okay.
I believe she was, but I couldn't... I was watching on a tiny little screen, to be completely honest with you.
There's a movement going. There's a movement. Yeah.
So today's hearing got off to a terrible start. There was no audio for the first many minutes of the hearing, and people online were going bananas. It was the pool audio that was out. Elizabeth Little was talking about something. Anyway, what I learned it was about, thanks to Ted Daniel, a reporter on Twitter. The defense began by asking the judge to reconsider her decision to deny the defense expert full imaging of the Canton police surveillance system. Brennan's response? The defense is welcome to come anytime to Canton Police and download the data, but he tells the judge they can't have free reign over the system because it contains videos from other cases.
Okay.
Sounds like a no, right?
Sounds like a sure if you can get there.
Yeah, I think that decision again is
I'm not going to help you with that. I mean, when have you ever asked for video from the Canton Police Department?
Right, exactly. All right, so this hearing moved very quickly, so some of these will be very quick.
Okay.
Brennan, the prosecutor Brennan, says he will not fight the defense request to have Karen Read's Lexus brought to 34 Fairview Avenue for the jury view.
Okay,
so the car will be there.
Okay.
Dr. Welcher, he was that Commonwealth expert that was going to testify on a bunch of stuff about how John O'Keefe died, and he had this 100+ slide presentation.
He was a brain surgeon, trauma surgeon. Okay.
Yeah,
right.
and anyway.
But not a pathologist.
Correct.
Yeah, okay.
Alessi got up and said he talked to Mr. Brennan and that they've agreed to a redaction of some of those slides and that they've come to agreement on it. And by the way, anytime they talked about evidence, Judge Cannone had to keep reminding them, I need to see this. You guys can agree all you want, but I need to see them.
That's right. I'm still the judge.
Is it admissible or not?
Nobody may like it, but I am still the judge.
And there was this interesting thing today. Robert Alessi, who's one of Karen Read's attorneys, he's the one from New York. Hank Brennan keeps mispronouncing his name as Alessi. And today in court, Jackson came up and very pointedly after one of his arguments said, Attorney Alessi. It was very funny. Okay, so next up, Lieutenant Garrett Wing. This is the defense's dog bite expert who was a cop in charge of the police units, is now a professional trainer, trains police dogs.
Not the physician, but another person.
He's not a physician, but the judge in this case has made it okay for non-physicians to give opinions about body stuff, which in the last trial she said they absolutely could not do.
All right. Progress.
Exactly. So the judge brought him up and said, Brennan, do you have a new report? Do you have a new filing here? And so Brennan said he has concerns about qualifications, that the guy has no pattern recognition analysis expertise. And he said, I will not hold the defense to the standard that he's not a medical expert. Okay, that was not the defense's standard. That was his standard that Cannoni said was okay. So this is Brennan just playing.
Yeah.
Okay.
Yeah.
He also said Dr. Wing had never testified in court before. He's asking for a voir dire of Garrett Wing before he testifies so that Bev can decide if he's a qualified witness. So that Judge Cannoni, I should say, should decide if he's a qualified witness. Alessi gets up and says, Hank Brennan is wrong here. There was an objection to our references in the report that Wing produced to Dr. Crosby, their witness, but we have removed those. Lieutenant Wing is experienced and qualified. He respectfully requested denial of voir dire and just to let him in.
Right. Okay.
No decision was made on there.
Okay.
All right. Defense motion for reconsideration, Crosby. Crosby is the Commonwealth's witness on dog bites.
Okay.
All right.
All right.
Judge Cannoni said she's not going to reconsider whether he's an expert or not, but she asked Hank Brennan, I don't understand how you're going to testify as to the specific dog that did or did not bite John.
Oh, right. So a pattern, but you need a comparison sample.
Well, Crosby claims he has taken a tooth mold of Chloe, and they plan to introduce that into evidence to say these bites couldn't have come from these teeth.
Do they fingerprint Chloe first just to confirm that this dog was actually Chloe?
As far as I know.
Does this even happen? This sounds like what they do with confidential informants.
Exactly. He's our confidential dog informant.
Yeah. All right.
All
right. But assuming it's Chloe.
That's right.
Move it. Yeah, what happens?
That's right. So she said, I don't have a problem with him testifying to things like I took the mold, I measured the teeth, but he cannot do a bite pattern analysis because, Judge Cannoni says, I've read the National Academy of Science report and bite mark evidence is not scientific and should not be admissible.
Oh my God.
Couldn't believe it.
A judge who has finally recognized the field of forensic odontology is bullshit.
Yes.
That's great, especially when it's a dog.
Right.
Well, I mean, we've seen this. They went to the, whatever the academy is for dentists or orthodont, whatever.
Yes.
They gave them all a series of bite marks, and there was no agreement among the experts in the field what matched or what was even human.
It was like 80% wrong or something like that.
Yeah, so in any event, okay, so he's going to do something, but he's not allowed to say, I mean, was he going to say these are the bites that match? Well, he was going to say these bites don't match.
That's right. He says, then he got up after she said this and he said, I've read the report too. I respect it. I rely on it all the time. But there's a big difference between inclusion and exclusion. And what he wants to argue is that there's, quote, definitive evidence that Chloe was not the dog. And that's when he brought up the mold they were planning on presenting of Chloe's teeth.
Who wants to be the person to stick their hands in Chloe's mouth with a little, a soft latex mold.
Even if Chloe's out cold,
even if out cold, I just feel like that's like putting your hand in a busted snowblower. Yeah. It could snap at any time.
Chloe has sent people and dogs to the hospital.
Yeah.
All right.
I mean, R.I.P. Chloe.
Exactly. So anyway, Bev Cannoni interrupted him and said, Brennan, this is an uphill battle. I was very surprised by
That's what she said.
Yes.
Words to that effect.
She was very, very aggressive about this. And then Alessi gets up, the defense attorney, and says, there's nothing in that Academy of Science report to suggest that exclusion is okay, but inclusion isn't. And Dr. Crosby doesn't have what's called an overlay, which would be required for human bite marks.
Right.
But even there's not even
almost like a transparency where you would just put it right over the top.
Right.
And
there's not any basis in science even in that regard, but he's not even offering an overlay.
Yeah.
And then Brennan gets up and says, there's no authority I'm aware of that prohibits exclusion. Also, it's a rebuttal for the third-party defense claim. So he mentioned that Chloe is part of this third-party defense claim, and so he'd only use this guy if they brought that up. And of course they're going to bring that up.
Yeah.
No decision.
I'm going to say that Chloe was one of the murder weapons. Okay.
Right, exactly. Right. Well, I don't think so. I think that she was just, in my opinion.
Well, yeah, I mean, if they could prove that those marks on John's arm are dog bites and they're Chloe, then that proves without a doubt that he went in the house.
That's right. But even the defense isn't trying to say we're going to prove it's Chloe. They just want to prove it's a dog.
They want to prove it's a dog. Yeah. Don't have to drill down that far.
And listen to me, America. I don't need a doctor to tell me that those are dog bites. Just look at any other pictures of arms with dog bites on the internet, and I've had my own experience with dog bites.
You can't tell me that that's the shattering of plastic through material and freckles.
Yes.
Okay.
All right. So next up, the Commonwealth wanted a substitute chemist. I guess their chemist isn't available. Everyone agrees to that. Mm-hmm. All right. So now there were some motions regarding audio and visual reciprocal sharing. So the prosecution plans to use extrajudicial statements Karen Read has made to reporters and on television and in print.
I.e. clips from her TV appearances.
Exactly.
Her many appearances, yeah.
And Brennan
Which, by the way, is the reason why many defense attorneys say, innocent or guilty, don't go doing that.
Right.
Because they might find you something tripping over your words. And then you say something like, well, they're going to say that when I hit John that I was drunk. And then you just hear, when I hit John, I was drunk. That's kind of how they came up with the I hit him, right? So
right.
Anyway.
Well, Canonia then reminded the prosecution, I still need to see all the clips.
That's right. Again, she's saying, I'm still the judge here.
Right.
Whether nobody here in the world wants that to be the case,
right.
I am yet still the judge.
And Brennan basically said he wasn't sure yet which clip he was going to want to use. One clip in opening statements, wasn't sure yet which one, but apparently he figured that out. The defense said they plan to use a visual image in their opening statement. Bev was like, we need to clear this up today because I do not want to bring you back for another hearing before trial.
Right.
That's Bev's way.
Was there an indication in court what that image was?
Nope.
Was it an autopsy photo or something like that?
There was no indication what the image was.
Okay.
So they took...
It's just a picture of Chloe with a little angel halo and wings painted on.
Right.
Yeah, okay.
So they take a little break at some point later, I'm just going to say, and they all reviewed the videos. The judge and the defense reviewed the videos and the image. And when they came back, they said they had no objection to any of the clips that the prosecution wanted to use, which is very telling.
Yeah.
So this was a weird one. The Commonwealth wants an independent reader or readers to read statements and or text messages with no emphasis in court.
They want radio actors to come in?
Yes.
What is this, the fucking Lone Ranger? Is this Fibber, McGee, and Molly?
And Canonia said, how are you going to find this person, right? And he's like, well, we could do plainclothes police or any other person the defense finds agreeable.
Is this probative?
The defense goes into a big huddle, all right? They came out and they said, we're in no position on this because Guarino was the person who read the John O'Keefe Karen Read text messages before during the trial, Nicholas Guarino.
Yeah.
And we think he did fine.
Right.
And I need to know more about what they plan to do about the, quote, theater of this independent reader.
Did I say which, okay.
Yes.
So they're not going to have somebody else read Proctor's text.
No.
They're not going to have somebody else read the Brian Higgins.
No. He wants text.
Okay.
Brennan got up and clarified he wants text messages between John O'Keefe and Karen Read read by a reader or readers. All right?
Okay.
Jackson got up. Jackson is pissed. He's like, this is theater. Guarino should be the reader because he's the one who found the texts.
Yeah.
Brennan had said we'll have to bring Guarino in and out of court all the time because, we might have to use the text throughout the trial. Jackson rebutted that by saying, Guarino is paid by the state. It doesn't matter how many times he has to come in. This is his job, right?
Yeah.
And individuals acting as readers, it makes no sense. It seems to add
precedent
theater.
For this?
Well, I guess there is, but he said it seems to add theater that's inappropriate. Canonia asked, would you have a woman or a man? Hank Brennan says, we can get both. Jackson says, we need jurors to read the texts and hear the text from the cop and not have a person read them. Basically, his argument is that despite Brennan saying there would be no inflection, Jackson's argument is if there is inflection, if there's any kind of inflection or interpretation of inflection, you can't put that back in the bottle. Again, Hank insisted there'd be no inflection, no decision yet.
Again, it just feels like a way to keep somebody off the stand that the defense might be able to impeach.
Right.
All right.
Another interesting motion. The defense has a motion for specific discovery. They essentially want notice if a Commonwealth witness is reluctant to testify, plans to change their testimony, or hesitant to testify.
Right.
They want disclosure of that. He said it goes to motive and credibility. That Yannetti made this argument.
Right. And so they are proffering that the Commonwealth has notes or other documentation that Mr. X plans to or suggested to prosecutors, I'll say something different next time. Or
I don't want to testify.
Or I don't want to testify. Or right, okay.
I don't want to perjure myself. I don't want to testify. Something.
Okay, so is that a bit of a fishing expedition? Do they know that such documentation exists? Like, would that be standard? Yeah?
I don't know if they know, but it seems to reason that they may have gotten a hint of something or a whiff of something if it did exist. And Brennan wouldn't be fighting it if it didn't exist.
Right.
Because he's fighting this one.
Yeah. Do you think that given a second chance that Colin Albert will stick with the claim that when he fell, he bruised his knuckles by not putting his hand out to stop his fall like every other human being would, but that he made a fist like Iron Man and broke his fall with that hand because he was holding a Dunkin' Donuts and the other, something goofy like that.
Yeah.
I think he'd like to have that one back.
It's unclear to me whether or not Colin will even be asked about that, because remember, he was precluded from being a third-party culprit in this case. That being said, if the door gets opened when he's on the stand, they can walk through it. You know what I mean?
Yeah.
Anyway, so it wasn't clear to me whether that order meant opening and closing statements or the entire trial. But if it's the entire trial, they may not be able to ask him about things like bruises on his hand. But if he opens the door to it, they can then follow up.
Yeah,
that's usually how it works.
See how far they can go on that.
Okay, so essentially, Hank Brennan said this does not go to their credibility at all, and he was very upset about it. And there's no decision on this yet. ARCCA witnesses. This got spicy.
Okay.
Hank Brennan contends very, very strenuously that he is not satisfied with the discovery around the ARCCA witnesses that he has received. He said that he's looking for information from ARCCA that would make clear the relationship between ARCCA and the defense. They've missed their discovery deadline. Now they want to submit new reports. And he said, quote, "My tolerance about this ongoing development of discovery is an extraordinary problem for me. This is the number one issue I anticipated and tried to prevent." He says this is why he filed so many motions. He's really upset about it.
Yeah.
Alan Jackson gets up and says, "No, the number one issue that Mr. Brennan has anticipated and tried to prevent is ARCCA testifying.
Yep.
Let's call it like it is."
Call it like it is. Yeah.
Yeah. So Jackson basically said they did not have permission to engage ARCCA directly for this trial until March 25th. That's like 16 business days ago.
Right. This part, because these were decisions made by the judge.
No.
Right? No?
These were decisions made by the Federal Department of Justice.
Right.
They received...
Which are so cooperative, I'm sure.
They received permission from the Department of Justice that they could now employ ARCCA as witnesses in this trial on March 25th.
Okay. All right.
So Jackson says if there's additional testing that they've done or reports they have, of course we will provide it immediately. We have provided everything immediately. It's going to be a matter of days. We're not hiding anything. As soon as we get something, we'll provide it. So Brennan's whole thing is this is trial by ambush. All right.
Okay.
ARCCA should only be able to testify to the reports we already have in hand, because he said something to this in effect. My expert provided everything in November. And Alan Jackson got up. This was a long back and forth where they both got up over and over and over again. And he said, "Let me re-edify you on the timeline. You gave us notice of your expert in November.
Yeah.
But we didn't receive any reports from him until February. Like February 1st, we received the first, January 31st, and then I reread it on February 1st. And then Brennan got up and called it the 5th, so I'm not sure about that. But anyway, essentially he's like, so this isn't true. Then just a few weeks later, we were able to engage our witnesses and we produced everything to you immediately. So Brennan is basically, he says, faux outraged, right? And essentially he's making up all these things about discovery and the defense missing deadlines. And he made the point that the prosecution filed their completion notice, which is they've disclosed everything, and yet they still keep sending the defense things. So the defense is still getting stuff from the prosecution, so they shouldn't be upset when they still get stuff from them.
So this is the legal equivalent of creating a file and then labeling it final, and then labeling it final 1, and then final, because you think it's final, but like more stuff keeps coming.
That's right.
Yeah, all right.
That's right.
But that's not your fault. That's the person sending it to you saying it's final. Oh, no, it's final .2. Right, yeah.
Jackson says on April 12th, they gave the prosecution thousands of pages in response to their discovery motion on ARCCA.
Mm-hmm.
And Jackson says, we did not give them anything we don't have, and we can't give them anything we don't have. Again, we could not engage these experts until we could engage these experts, right? And again, he said they gave both sides permission, the Fed did, to engage them on March 26th, all right? So Canoni has an interesting question. She said, last time I heard these witnesses, to me, it wasn't clear which one did what in the report and their investigation and report.
So like which ARCCA expert did this thing and which one did that thing, right? Okay.
Which, by the way, I watched her testimony and that's not true. But she says they said we a lot, which they did. They meant we the firm.
Right.
Jackson got up and correctly said, I disagree with that. They both talked about what they each did. Rentschler did biological stuff and Wolf did mechanical stuff, is essentially. And then Judge Canoni didn't disagree with that.
Were both allowed to testify? I thought that was a point of... Okay.
It was a point of contention, but both were ultimately allowed to testify. Canoni asked an interesting question. Is there anything that ARCCA can't provide, meaning that you can't provide, because of the federal investigation? So Jackson says, the one thing the government has said they are not allowed to detail are their confidential communications with the Justice Department.
Okay.
Canoni says, but can they testify as to what they did and what direction they had when they did it? And Jackson says they can't testify about their communications with the government about what they were asked to do, but we know what they were given, which was not a directive. What they were given was evidence and told to come to their own conclusion.
Right.
Canoni asked, do you have everything from ARCCA that you need? To Jackson. Jackson says, yes, we have no reason to believe that we don't because it came from them and the feds. Then she asked about this subpoena that Yannetti mentioned at the last hearing where he said they'd received a subpoena from the DOJ to turn over their whole case file and that they've been disclosing things to the DOJ ever since. Brennan seemed to interpret that as they just got a subpoena, but in my opinion, it wasn't that they just got it. They were talking about an old subpoena, and Yannetti clarified that it was in fact an old-ass subpoena that they had received in 2022. All right?
Which is still in effect, and they continue since 2022.
Apparently they continue to share
Okay.
everything.
Okay.
Brennan got madder and madder and madder during this, all right? He is essentially like, I do not believe we have received everything, to which I say, just because you say it doesn't mean it's true, okay?
Right.
He says the defense has dragged their feet, they can't prepare, that, they won't be able to, we're at a disadvantage. It's trial by ambush over and over and over
It's
again.
like the upside down. Everything about this just sounds like the Commonwealth is preparing like they are the defense and are entitled to all of the protections and privileges of the defense.
Right.
And that the defense is so aggressive.
They want all
that they're
the discovery.
moving. They're moving like they are the prosecution.
That's right.
This is just so weird. Yeah.
So Jackson then reminded Brennan that they got the final version of Welch's report, which was different than the previous version.
And Welch is
the state's counter expert to ARCCA. Right?
Okay. Yeah.
They got his final version of his report with all the changes that had to be made on March 24th. This is just a few business days ago.
Right,
okay.
Right.
And then Brennan gets up and says, rather than address anything, they're always assigning blame. They're assigning blame. They want to blame everybody while they're ambushing us. There is no ambush, Jackson said. No one is at a disadvantage, et cetera, et cetera. No decision. But it was spicy.
That sounds interesting.
Next up,
Yeah.
Hank Brennan wants to exclude the conclusions of the internal affairs investigations into 4 police officers.
Okay. All right. Let's start. Who are the 4 officers?
Michael Proctor,
Uh-huh.
Yuri Buchanan,
Yeah.
Brian Tully, Kevin Albert.
Okay.
All right?
Okay. All right. Conclusion. So if I'm picking up what you're putting down, he's okay, or he's not going to object to the jury finding out that these 4 officers were investigated either by internal affairs or whatever body, but he doesn't want the jurors to know what they found, or if they were disciplined, or if there are otherwise the reasons to believe that they may not be completely truthful.
Do you know what his argument is about that?
No.
That the people coming to the conclusions in these investigations were a third party.
A third party?
That's what he says. It was a third party conclusion. And so therefore, what he's implying is the conclusion might be in some kind of question because it was a whole other party.
A whole other party.
You know who does internal affairs investigations, Kevin? The state police.
State police. So, okay. So we can't, look at what happened with Proctor because he wasn't investigated by the state police. He was investigated by the state police. Mm-hmm. A whole other...
Then they came to a conclusion.
A bunch of other people that do this. Yeah, I mean, who? Oh, for hell. Oh, Buchanan 2, Brian Albert, Canton Police Department.
No, Kevin Albert.
Kevin Albert.
Yes, and there's a lot of Alberts.
Okay, there's a lot of Alberts. But also Brian Albert's got some bullshit in his background, right?
Oh,
like punching his partner,
sucker
punching.
I read
great.
the complaint. It's online. You can read the complaint that was filed by his partner.
Okay.
Anyway, so... Elizabeth Little got up and said something very interesting.
The attorney for the defense.
She said they had come up with some kind of, they had been talking, and her understanding had previously been that he just wanted to exclude the conclusions, but this morning he told her he wants to exclude everything about the internal affairs investigation.
It's a bullshit argument. That makes more sense than to say. But, I mean, the states have created whole lists of officers who are on a do not call list. In New Hampshire, it's called the Laurie list, which is citing the case. They are required to turn that over as exculpatory that this cop and this cop and that cop once lied or they did this or that for the purposes of cross-examination. Right. And now they're saying, hey, these 4 cops...
It's a crazy argument.
It's a crazy argument.
So Cannoni basically said, I need this in writing.
This must have been full-throated, right?
It was pretty full-throated.
Yeah.
I need this in writing. Elizabeth Little was like upset.
Yeah.
Cannoni said, I need this in writing, Miss Little. And then Little said, I'll get that to you today, but we need you to decide before Tuesday. Mm-hmm. Essentially what they're saying is they're going to say this in their opening arguments, right?
That's right. You're going to hear from some cops.
Right.
Stuff happened. We can't tell you just yet.
So then they took a break. They said it was 15 minutes, but it was longer. That's when everybody watched the video. They came back. No one had any objections to what they were going to use. Little then addressed this issue again about the internal affairs investigations and said, I spoke to Mr. Brennan during the break. We're in agreement on most of the issues, including the sustained findings of Proctor, Buchanan, and Tully. So I guess they agreed that the results would come in.
Okay,
but we still need to work issues out around Kevin Albert. Mm-hmm. And she said, we'll keep talking to them in the next day or two and tell you what the results are. All
right. So Brennan decided I'm not going to give them an appealable argument before this even starts.
Exactly.
Okay, all right.
Exactly. Finally, there was a motion to remove Aidan Carney, a.k.a. Turtle Boy, from the sequestration order, meaning that he could come to court, observe the trial.
Right, because if he's a regular witness, he wouldn't be able to, and the fact that he's on the witness list is a whole pretext for just keeping him out of the courtroom.
That's right.
It's just a big F you to him.
That's right.
Yeah, okay.
So
he's never going to get called as a witness, but this is just the whole purpose of putting him on it.
Timothy Bradel, Aidan Carney's attorney, showed up, and he was the one who was arguing this. Before he even got a chance to argue it, Judge Cannoni turned to Hank Brennan in a surprising turn and said, do you even plan to call Aidan Carney as a witness?
There you go.
Okay?
Yeah.
And he said, I swear to God, I don't know yet. I don't know if we're going to use him. If they put Karen Reed on the stand, we may use him to rebut, but we'd have to assess as the case develops. This is the same man who is saying the defense needs to do everything they can and give them everything and blah, 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 blah. But he's like, I don't know. All right. And so Bradel said, they're not going to call him. And if he's called, he's going to take the fifth anyway. Because remember, he has all these pending cases around some of the witnesses in the case who have accused him of witness intimidation.
Right.
Total bullshit charges. That's just an opinion I have about the charges, not about Carney in particular and his actions, but the charges themselves.
Right.
But our attorney says he plans to take the fifth. And Cannoni says, well, if I don't sequester your client, the witnesses who are subject to indictments in his case, he would have to leave the courtroom as he did last time for their testimony.
Right.
And Bradel says, we anticipated that might be your conclusion. We don't necessarily agree with it, but we'd be okay with it. All right. So, he basically wants Carney to be able to cover the trial from in the trial.
Okay.
Brennan then says, because the judge asked him, if he's going to assert his Fifth Amendment privilege, I no longer have a good faith basis to request sequestration because I'm probably not going to call him. All right. So Cannoni then says, well, could he do that now? And Bradel says, we assert. And Brennan interrupts and says, that's not good enough. I need to hear it from him. He wanted Turtle Boy to assert it himself. Cannoni says to Brennan, do you agree that he has a Fifth Amendment right? She used the Fifth Amendment rights instead of privilege.
Yeah.
Brennan said, I believe he does, but not to all the questions we might ask. The content we would ask him about that he has a privilege around, he believes there is a Fifth Amendment privilege around.
Yeah. I mean, there's usually in a case where a judge will not allow a witness to come solely for the purpose of being used as a prop so that the jury can see them take their Fifth Amendment
Right. That's
privilege,
not okay.
Right.
It's not generally okay.
That's right. That's not generally okay.
It's different in civil depositions.
Yeah. Yes.
Civil attorneys love it when people sit there and say, I plead the Fifth, I plead the Fifth, I plead the Fifth.
It's funny because we actually wrote a book where this happened, and it was the only time it happened was because both the defense and the prosecution believed that this one witness invoking her Fifth Amendment privilege both, advanced their case.
Right.
So they both wanted it to happen, and the witness ended up coming up and doing that, but outside the view of the jury, and that was that.
So Bradel then asked one more time, I'll ask you, Judge, to let me make the representation, and we can just leave it there.
Mm-hmm.
Cannoni says, Brennan, do you have an issue with that? And Brennan says, I do. I need to hear him say it.
Again. So he made that statement more than once.
Yeah.
I need to hear him say it.
You know what? He wants the tape of it.
Yeah.
You know what I mean? He wants it like in open court. He wants a video of it or whatever.
Yeah.
So Judge Cannoni, acting like a real judge today for like the fourth time, said, no, we'll do it at my bench, cameras off.
Mm-hmm. There you go.
So he will be exempt from the sequestration order except during the testimony of the witnesses who are alleged victims in this case. In his cases, right?
Yeah, his cases.
Brennan says also the minor children, and Cannoni said that's fine. The minor children could be, because everyone is sequestered from the minor children.
Sure. Okay, that's fine.
And that was the end of the hearing today.
Wow, a lot happened.
Yes.
A lot happened.
Yes.
At some point, we have to talk about that mass accountability guy.
Yes.
And his videos where Colin Albert and Chris Albert went to the police.
Can we just talk about that for 3 minutes?
Sure.
There's this dude who has an account called Mass Accountability, Mass as in the state of Massachusetts. Yeah. He is kind of turtle boyish. Like he does things that he shouldn't, and I would never recommend anybody do. But he put up some very interesting, essentially raw video, just edited in big chunks that he voiced over. Mm-hmm. He had tweeted a little while ago that he went to Canton and he was being followed around, and he put the pictures of the car that was following him on social media, and everyone
he wears like a body-worn camera,
he wears
right?
A body-worn camera.
So these get everything extemporaneously.
And Twitter said, that's Colin. And Colin drives this very distinct black Jeep.
Like, who's that dude? It's Colin.
Right. So he, instead of reacting immediately, he went to the police because he had knowledge then that Colin and his father, Chris Albert, went to the police and filed a police report against him for following them.
Mm-hmm. I think they try to use the term stalking.
They called him a stalker. So he then obtained that body cam image of that interview.
Of the cops, yeah.
Yes, and he made a very interesting video where he documented his whole time in Canton. He's like, here I am, standing across the street from D&E Pizza. Mm-hmm. Colin comes out and stares at me. Mm-hmm. He gets in his car, which is like a vintage old car, drives down the street, sees Colin pull out and realizes that Colin's going to follow him. He flips around so that Colin won't follow him, and yet that day, Colin keeps following him. Mm-hmm. He decides to go to the Canton police station for something, who knows. And, he said he wanted to see if the second floor was accessible or not. I don't know why. Mm-hmm. And he has video of all of that. He tells the audience he's parked at the graveyard down the street from the police station. He goes, in my experience, you never want to park in front of a police station because then they'll have your tags.
Yeah,
whatever.
right. Okay.
Which, by the way, if you're this guy, probably makes sense.
Yeah.
So he's standing there, and he has video of Colin driving past and looking at him, turning around, driving the other way to look at him. So he has this extensive video of Colin following him. Mm-hmm. And then he plays the video uncut of Colin Albert and Chris Albert going to the police station and doing a police report about being stalked by this guy.
Right.
And the cop is essentially like, well, I mean, I can go look up the definition of stalking, but I don't think this rises to that.
Right. I mean, we typically think in the legal world of stalking as a situation of like ex-boyfriend creeping around, that world, right? Not, I followed you around, I intimidated you. That's not.
But this is I think
criminal threatening,
right.
Menace might be a term. Yeah.
Yes. Now, keep in mind, Chris Albert now has another complaint against Turtle Boy for speaking directly into his camera that's facing the street in the pizza place when he was out. He was out one night at C.F. McCarthy's, which he probably should not have done.
Yes.
But these people, and I think this speaks to all of the other cases, and I believe that this could be used as evidence in one of Aidan Carney's cases. They weaponize the local police.
Exactly.
And there is now video evidence of them attempting to weaponize the local police against a guy who, rightly or wrongly, was documenting downtown Canton, Massachusetts. He has video evidence of Colin following him that is clear as day.
Yeah.
And then he has the body-worn camera of a cop interviewing Colin and Chris and them lying about what happened and trying to get this guy in trouble, weaponizing the police.
Right. This is not a legal observation for me, but just a behavioral observation, which is kind of along the same lines. These are people who have come to believe that they can use the police as a security blanket and as a way to, as you say, weaponize it, to get people to do what they need them to do.
Right.
And where that comes from, where that was learned, I mean, I guess if you're
Chris was a cop.
in a family of police officers,
Yeah.
you think, why? Because if I can't convince you to do X, Y, or Z, a police officer can.
We'll come bully you anyway.
Right. And not just any police officer anywhere will, we'll try to enforce that law, but especially we see what happens with these particular cops, the ones that they hang with, they have no qualms about throwing up bullshit to come after you. So you're right. So they do, again, have this pattern of trying to weaponize the police.
Right.
Then how can you possibly wonder about the accusation that someone like a Proctor or a Ukenick or any of those cops that are involved in this investigation would go the extra mile to
both the Canton police and the state police.
Yeah.
They have both because remember, they were all friends with the state police cops.
Yeah.
And the local police, Kevin Albert is a member of the local police department and Chris Albert used to be.
All right.
So anyway, that happened. I found it so fascinating. I will post the link to this guy, Mass Accountability's video. Again, I do not endorse what these guys do and how they do it, but I will concede he captured some incredibly important, in my opinion, video. This is what happened to the Canton fence guy, Kevin. The Canton fence guy. They made a complaint to the police saying that he was harassing and intimidating them. They conducted a 6-month investigation, and the judge dismissed the whole case.
Yeah.
So anyway, that's where we are. Opening arguments on Tuesday.
All right, we'll see.
Should we say it again? Let's fucking go!
Let's fucking go! All right.
All right, Kevin. Thank you so much for joining me on the Readathon.
You bet.
Partners in Crime Media.